Hi, welcome. I'm Dave Stiegel, one of the shareholders at Lawton and Cates, and today we're going to talk about an independent medical exam. And I'm going to tell you why I don't think they're independent, nor are they medical exams. As always, if you wish to learn more about me or our firm or the services we provide, you can do so by visiting our website through the link below. If you'd like to talk to me directly, if something I say sparks a question, you can always either pick up the phone and call me in the office or send me an email. That contact information is also located below. So today's question or today's topic comes from conversations I have in almost every, certainly workers' compensation case. If you're injured at work and the insurance company doesn't want to pay you, the legal way they go about it is to arrange for what they call an independent medical exam. And the law allows the insurance company to select a doctor, retain that doctor, to provide them with an opinion about the compensability of your claim, whether they should pay you in the first place, the extent of your disability, the necessity of any medical treatment you have, and the extent of any permanent injury that you may have suffered. Now, keep in mind, your treating physicians and the people that are in charge of your care have nothing to do with this process. You don't ever form a patient-doctor privilege with the independent medical examiner. He's there or she's there simply to provide an opinion to the insurance company, simply put, about the nature and extent of your injuries. Okay? So here's some of the nuts and bolts that you should know. First, they can have you see someone within 100 miles of your primary residence. Okay? So keep that in mind. If they ask you to see Dr. Joe Smith or Dr. Jane Smith and they're 500 miles away or on the other side of the state, you should tell them, hey, I believe I only have to travel within a 100-mile radius. Okay, so keep that in mind. Second, the insurance company is responsible to pay you advance costs of the consultation. Oftentimes that relates just simply to mileage. They'll send you a check for mileage from your residence to the location where you're going to meet the medical examiner, the doctor. Okay, and here's the rub, so to speak. You have to do it. If the insurance company, the workers' compensation carrier, often wants you to attend an independent medical exam, oftentimes you have no choice. If you don't do it, it'll act as a bar against your claim. So you can't recover anything unless you go through the process. Okay, so here's the nuts and bolts. Or there's the nuts and bolts, and here's my takeaway. You should absolutely go through with the independent medical exam. Just know it's not independent. The doctor that the insurance company hires is not somebody that has your best interest in mind. That person is writing a report to appease the insurance company and very much wants to make the insurance company a repeat customer of the doctor. Okay? There's lots and lots of doctors that don't do anything at all except write reports for insurance companies that are later used as a basis to deny claims. Okay? So on your end, preparing for an IME is easy. Number one, just resign yourself that you have to do it. You don't need to make it unpleasant, but you're going into it eyes wide open. Number two, tell the truth. That's all you have to do is tell the doctor the truth. You don't have to exaggerate your injuries. You certainly shouldn't undercut them. You should just tell it to them straight. Again, remember, this is unlike any doctor consultation you'll ever have. This person is not interested in your best care. They're not forming a doctor-patient relationship with you. They're there simply to evaluate you and write a report for an insurance company. Okay? When you get your report, oftentimes it's accompanied by a denial letter. The insurance company will send you a report saying, based on the report of Dr. So-and-so, we're no longer going to pay you benefits, or we're only going to pay you benefits up to this certain amount. Most IME reports, in my opinion, are essentially pre-written. Now, I don't mean they're actually pre-written. I just mean that the outcome of the report is already predetermined. The doctor's going to find a way, as best he or she can at least, to conclude that you either weren't hurt at work so they don't have to pay you, or that if they can't say that with a straight face, that you were you're not hurt as bad as you're claiming you are, and you certainly didn't suffer a permanent injury. One of those three conclusions are the most common that we see from the from these IME work comp doctors. So what you can do is if you get an IME report and it's accompanied by a denial letter, you'll know it's a denial letter because at the bottom of the letter it'll say, if you disagree with this decision, you can file for an appeal through the Department of Workforce Development. That's the agency that oversees the work comp system. Okay, so my advice to you, if you get an IME report with a denial letter, that's the time you want to reach out to a workers' compensation attorney to discuss your options at that point. Okay, if you have questions again about the IME process, those aren't typically suited very well for public forums, so I'd urge you to either contact me or another attorney so you can discuss some of your specific concerns, maybe in a little bit more private fashion. But to recap, for the IME, the insurance companies can make you do it or you can't recover. They can only go within 100 miles of your residence. They have to pay your mileage up front, and you should go to the appointment, tell the truth about your injuries, and then wait to see your results and perhaps consult with an attorney. Okay, that's it. Best of luck. As always, thank you again for giving me your attention. I'm Dave from Lawton & Cates. If you have questions or something I said sparks something you'd like to talk to me more about, feel free to contact me.